Hello everyone, I'm Elodie Abba, Senior Legal Researcher at the Business and Human Rights Resource Center. And on behalf of the center and our partners, LEADE, ActionAid International, Center for Applied Legal Studies, Canadian Network on Corporate Accountability, the International Federation for Human Rights, Lawyers for Human Rights, and Zimbabwe Environmental Law Association, we're delighted to welcome you to the third webinar in our annual three-part series this year, is entitled 10 Years On, a call to concrete action for a powerful, legally binding instrument. For your information, this webinar is being recorded, and you'll be able to access the recordings of all the webinars in the series on the Resource Center website. So for today's session, it's about some of the most debated provisions of the treaty, those considering its scope, and since the negotiation started several years ago, this has been really a hotly contested ground. So the resolution of the question of scope, or which companies will ultimately be covered by the treaty, is really essential to finalize the proposed treaty text. So our panel today is comprised of seasoned legal experts who will guide us through this task as we explore the benefits and limitations of the different options about scope, and as we consider how they would also work in practice and what their impacts would be for companies, states, and rights holders. So the panel will be moderated by Michael Clements, the Director of International Programs at the Business and Human Rights Resource Center. And before handing over to Michael, who will introduce the panelists and also facilitate the discussion, I have the privilege of introducing our keynote speaker, Fernanda Oppenheim. Fernanda is the chair of the UN Working Group on Business and Human Rights, and she's also the co-executive director of PODER. It's a Mexican NGO dedicated to corporate accountability. And for over 20 years, Fernanda has worked with and supported local affected communities in Latin America seeking justice and access to remedy. She was a member of the Treaty Alliance and also a founding member of the Feminists for Binding Treaty Coalition. So Fernanda will provide her remarks and depart a little bit before the end of the meeting to join another engagement. Fernanda, the floor is yours.
Thank you very much, colleagues, and apologies. Delegation is passing by. I'm in Geneva in the Palais des Nations. They'll be out in a second. Thank you to the organizers for this invitation. It is my pleasure to be part of these conversations. As many of you may know, even before, of course, joining the working group 3 years ago, I have been following all the discussions and the negotiations around the legally binding instrument since the adoption of the resolution in 2014. And this has been an area of work for me and of engagement and interest, again, before joining this particular mandate of the special procedures in 2021. So the first thing I wanted to share is that the working group, at least for the last, I would say, 5 or 6 years, has been very explicit about its support to the process of negotiating and developing and eventually implementing a legally binding instrument with regards to the protection of human rights in the context of business activities or business and human rights. We consider that there is no contradiction between the guiding principles and adopted in 2011 and the process of the treaty. That is in part because the UN guiding principles are an international standard that can guide different sorts of conversations and result in different types of developments, including international instruments. As you may recall, the guiding principles refer to a smart mix of measures to make sure that human rights are respected and protected in the context of business activities. And that smart mix, again, can be composed by public policy, national regulation, strengthening the justice system in our countries, developing international instruments, and so on and so forth, including initiatives by the private sector. So again, we see no contradiction, and we are in full support of the development of this instrument. In my experience, since I joined the working group, the chair actually of the Intergovernmental Working Group, Ecuador, and other stakeholders have come to us to discuss a little bit some of this very contested or challenging elements in the treaty, different drafts and in the negotiations, being the scope one of it, right? As this is what brings us to this webinar today. So maybe I'd like to share a few reflections on the issue of the scope. Despite the fact that the resolution in 2014 passed with an emphasis or a specific mention to transnational corporations, you may all remember that famous footnote that included this, and that was what gave the possibility for many states to support or abstain, but not block the passing of this important resolution to create an intergovernmental working group to negotiate this instrument. The guiding principles actually refer that all companies, all businesses in all sectors, despite their size, are responsible for the respect of human rights in their operations and in their business relationships. So it is my view that excluding some businesses could be something that is not only misaligned with the current international standards that we have, but also could create some challenges, and I'm going to address those in a moment. First of all, I think a question that my fellow panelists will address is how would one make the difference and really legally define what it means to be transnational or to have a transnational operations or operations of a transnational nature, and what it doesn't. So that's one thing that I think could be challenging if we just keep the focus on transnational corporations. Of course, not only human rights abuses can happen within small and medium companies. That is obvious. We don't need a treaty, I think, to address that, though. We should have enough domestic regulations to make sure that small businesses comply with their responsibility to respect human rights, that there is no exploitation of workers, that it's no environmental damage or other forms of human rights harms in the operations or the activities of small, medium enterprises. But I think that if we exclude certain types of companies from the scope of the treaty, then this could potentially create certain loopholes that actually some big companies could profit from or take advantage of, changing the registration as they sometimes do in our own jurisdictions, or finding some legal avenues to protect their interests and avoid the responsibility. So I think this treaty, as important as it is as a potentially legally binding international instrument, should try to prevent those things from happening. I think many CSOs, many of the colleagues that are probably here, either connected to the webinar or part of the panel, have worked on different issues, including how companies do what has been called jurisdiction shopping to avoid the responsibility, right? And so I think this is a potential challenge that could arise from excluding certain companies in the scope of the treaty, or to say it differently, to just focus on a certain type of companies. And the other thing I would say is that this could also create a challenge to hold accountable state-owned enterprises or enterprises that have, in part of their capital composition, some participation or majority participation of states. We have many examples around the world of very big state-owned companies, of course, that operate transnationally, but they also have vast operations in their own territories. I don't know, I can think of Saudi Aramco in Saudi Arabia, or some very, very large Chinese state-owned companies, or even in our region, like Pemex in Mexico, or Petrobras in Brazil, or other very big companies. I'm evidently from Latin America, where I can find more close examples of very big state-owned enterprises that are have operations that actually have caused and continue to cause human rights harms. So in that sense, I would invite us all to think about these challenges and consider that maybe it's better to have all companies comprised within the scope. This is a recommendation the working group has done. It's public. And we have also offered this recommendation to Ecuador as chair and to other states that have consulted us. I'm sure that not all of us will agree on this, so it will be fascinating to hear your thoughts. But I wanted to share these reflections again from the working group perspective. And let me just end by saying that I think there is one important element, Elodie, when you were projecting the last parts of the draft that address this particular issue of scope, there is a mention to business relationships. Business relationships, of course, are covered under the guiding principles for all companies, despite the size, again, or the nature of its operations. And it's covered by other regulations that are being developed, like CSDDD, or the Corporate Sustainability Due Diligence Directive, just adopted by the EU, and by other laws or regulations that tackle specifically human rights due diligence. But I think business relationships can somewhat solve some of the challenges in terms of operations in many jurisdictions, and business relationships or supply chain issues that we can see have also posed a lot of challenges with regards to the protection of human rights in businesses. So let me end there in the sake of time, and I remain at your disposal for any questions or comments. Thank you very much.
Thank you so much, Fernanda, for sharing, I think, what is an incredibly valuable but also nuanced set of perspectives on this issue. And I know you've shared them as both an activist and as the chair of the UN Business and Human Rights Working Group, a really excellent foundation for our discussion today. So thank you. We'll turn shortly to our panel of experts, which was initially to be moderated by Richard Mirren of our partner Lead Day, who unfortunately is not able to be with us due to a personal emergency. But just briefly, I think building on Fernanda's excellent exposition, we'll all recall that back in 2014, when this process began, there was considerable skepticism as to the viability of an LBI at all. Business was generally outright against going beyond the voluntary UNGPs. Others said that while civil society and some states could regard the UNGPs as a stepping stone to legally binding principles, going beyond them would be a tall order, which I think we all probably agree with at this point. The EU participated in negotiations as observers only. The US was absent and then joined more recently. Although robust participation by civil society from across the world and from global South states in particular was notable from the beginning, and so it remains. Much has changed since the initiation of those negotiations, which our webinar last week delved into in some detail, and please visit the recording on our website if that's of interest. But certainly, as Fernanda picked up at the end there, this includes the really clear momentum behind the drive for mandatory human rights due diligence and corporate accountability around the world. We're seeing that, of course, in France and Germany and the EU with the recent passage of the CSDDD, but other laws and initiatives are notable around the world in Brazil and Korea, Mexico, the African Union, Australia, and others. All of this, of course, is really important progress and good context for our discussion today. I can say that as the Business and Human Rights Resource Center, we have been tracking for 20 years examples of corporate human rights abuse, and all of that's persisted, notwithstanding the introduction and implementation of the very important voluntary UNGPs. But the proposed treaty, which, as you've heard, is an advancement of those principles, represents a really important step forward in shifting from soft law initiatives towards binding standards. And resolution of the question of the treaty scope is, of course, one of the most critical steps in getting us there. And our panel will delve into this in more detail. To that end, I'm delighted to be able to introduce these experts. First, we have Enes Udera, who is a business and human rights lawyer at the Center for Applied Legal Studies in Johannesburg, South Africa. We're also joined by Kinda Mohammadi, a legal advisor at the Third World Network. Her research is focused on investment in trade law, corporate accountability, and international human rights law, and she was recently appointed as legal expert for the Intergovernmental Working Group on the treaty. Carlos Lopez is an independent senior consultant on business and human rights and a professor at the Catholic University of Peru. He's worked in this space for over 15 years, including at the International Commission of Jurists and the OHCHR. And finally, we're joined by Ray Lindsay, who's a partner at Clifford Chance's litigation and dispute resolution practice and co-head of the firm's public international law, ESG risk, and business and human rights practices. For our audience, please remember that you'll be able to submit questions throughout the session using the Q&A box on the bottom of your screen, and we'll pick those up at the end of a few rounds of questions with our esteemed panelists. So turning to that, just to set the broad scene, I think I'll first ask for reflections on the following from each of our participants. The definition, as we've heard and seen already, of transnational corporations and of business activities of a transnational character are obviously key to the elaboration and implementation of the treaty going forward. Are there elements, and do you see elements of that definition that you could think that could be amended to make it more workable in practice? And Enesu, I'll turn first to you, and then we'll do a round of our panelists.
Thank you so much, Michael, and everyone, for this opportunity. So I think my task really is to shape or bring in a human perspective, right, on why corporates or TNCs, should be held accountable for human rights, violations, right? So I think the foundation is laid really through trying to understand, right, the affected communities and the affected people, right? So you realize that TNCs, most of their operations, right, take place in the global south, right? Due to issues or factors such as, cheap labor or the availability of, raw materials, but also the governments in the global south always, has this need to attract investors, to attract TNCs, because they see this as an opportunity, right, to create employment for their people, an opportunity, to call upon investors. But then what often then happens, right, a lot of times is that most of the TNCs, right, invest in countries, right, where, even the GDPs of these countries, right, are even lower than, well, perhaps the network, right, of these TNCs. So you realize that the power dynamics, right, between the host country, for example, vis-a-vis the TNC, right, that is conducting operations in that particular jurisdiction is different, right? So now it is important or crucial, right, for TNCs to be held liable, simply or in summary, for the following reason. Number one, firstly, right, they are responsible for the human rights violations through the operations they will be conducting in that, particular jurisdiction. So if it's in the extractive industries, such as, mining in the global south, you realize that the nature or extent of the operations are precipitated by these TNCs. Then secondly, as I have highlighted, most of the jurisdictions really in which these TNCs operate, the countries are poor to an extent that if you try to get remedies from the host nation or from the countries or from the government of that particular country, for example, DRC, etc., right? You might not even be able to get an adequate remedy. So it's always good, or it will always be ideal for victims to get remedies or to hold TNCs accountable because of their financial abilities, but also because of the direct link really between the activities and the violation. But also, overall, there is need to send like a deterrent, right, message to other TNCs to say that, if you operate negligently or in this kind of manner, then these are the consequences. So now there is need for TNCs to be held accountable, so as a broader way of sending messages to other TNCs operating or carrying out similar activities. But also, secondly, as I've highlighted, there is need really in general to hold these TNCs accountable because of their muscle or financial power. And also, lastly, as I've highlighted, most of the countries attracting investors, they are poor, financially. And as a result, they are more desperate to call for investors or for investments, at the expense of the violations, of the TNCs that are operating in their jurisdiction. So now, for the sake of protecting or safeguarding, also their reputation, is always really important to hold them accountable, so as to keep them in check and also to ensure that the victims of violations get the adequate financial remedies that are proportionate to the violation that has taken place. Thank you.
Thanks, Aneto. I think a really important grounding perspective for the rest of this discussion. So many thanks. Kinda, could I ask for you to come in?
Yeah, sure. Thanks a lot. In principle, I agree and I understand the argument presented by Anissa, and also the interest of a number of negotiating member states to focus on transnational corporations, which precisely come from what Anissa had reflected on, this unique ability and power for these entities to escape the jurisdictional reach of states, and basically in doing so undermine regulation and accountability mechanisms. And there are a lot of empirical evidence that shows how corporate structuring, which is referred to sometimes as the carefully designed group risk allocation, basically has a correlation with the ways companies attempt to avoid the risks of litigation, or separate these risks between the center where the profits basically flow and the liabilities in the areas where the conduct or operations underlying this profit making take place. So these are legitimate concerns, but I am not sure that by we could achieve these objectives designing the LBI around the notion of transnational corporations. I think these objectives can be achieved and ensured more effectively through focusing on the way the operational parts are designed, particularly the parts pertaining to prevention and due diligence, adjudicative jurisdiction, legal liability, and international cooperation. This is why I think when we want to discuss this scope in light of the objectives, we don't have to necessarily focus on Article 3, etc. The definitions would work out in light of the operational sections. Now, if you want my opinion about investing in defining transnational corporations in the context of negotiating the LBI, I think it will be a futile effort. I would I think that there is no added value in investing the time and effort in negotiating a definition for transnational TNCs. I recall that we don't have a precedent to base on. We can look back at the intergovernmental negotiations in the 80s around the Code of Conduct for transnational corporations, and there they attempted a definition, and it was really highly complex, would require significant amount of information on the corporate conduct, the corporate decision making, etc., which would make it really create loopholes, as Fernanda had mentioned. So, and I understand as well that the LBI is not meant to focus only on, businesses that incorporate, let's take the form or the legal form of a corporation, but like on broader legal forms of business entities. So, so I would pay more attention to the definition of business activities and business activities of a transnational character. And here, for sure, we have a good grounds, but for sure we need to work more on clarifying the design of these definitions. For example, in the definition of business activity, it's important to revise it for more clarity, to distinguish general activities from the economic and commercial activities. So, for example, using terminologies as other activities would not be helpful in that regard. Maybe we can, tweak it in a way that focuses on the activities related to the I can note that the LBI, and when we're talking about the taken by natural or legal persons, this is broader than the directive and the guiding principles, which focus on the legal persons. So it is, and I agree that the focus should be broader. Particularly because also the LBI is not only focusing on due diligence, for example, such as the EU directive. It's also focused on victims' rights. It's focused on legal liability standards. So it requires this broader approach. Now, on the definition of business activities, I would say that we need to also revise it more attentively. We need to clarify what do we mean by a business undertaken in more than one jurisdiction? How does that differ from a business who parts of it, such as its distribution or its marketing or its research, is done in multiple jurisdictions? So this, the difference between subpoint A and subpoint B in this definition. I would advise against a closed list of elements under the sub point B, which the elements which would constitute a business activity, because also that would create loopholes. A more indicative, open-ended list is useful. So these are the kinds of changes that I would suggest focusing on this definition. Thanks.
Thanks, Kinda. Really rich reflections, and interested to hear others' responses. Ray, can I hand over to you?
Thanks, Elodie. I'll say from the outset, I think there are many on this panel who are much more immersed in the details of the treaty negotiations than I have been as a private practitioner. So I think it has been the sense for some time that the treaty wasn't going anywhere fast, but there seems some renewed focus on the possibility of progress and more engagement by some states, for example, who haven't been particularly engaged in the process to date. And so I welcome this opportunity having had a chance to look at some of the issues, and in particular on scope. And on that, I mean, everything I say here is, as I say, relatively uninformed, and my own personal views just based on looking at the treaty draft as it currently stands. On the particular issue of scope that we've been talking about, so the first question is obviously premised on the definition of transnational cooperation and business activities of a transnational character, neither of which need to be dwelled upon if, as Fernanda says, and I think Kinder largely agreed with, the scope of the treaty relates to all business enterprises in the same way as the UN Guiding Principles. So I do think that there's going to be more progress made, and it's more rational to proceed on the basis of all business enterprises in principle being in scope. And then thinking about exactly what the objective of the treaty is in order to define how the activities of those enterprises are going to be regulated in relation to preventing harms and so on, the other provisions in the treaty. The details of the definitions here are complex, vague, interrelated, and certainly I think the negotiations would be speeded up if the concepts were just abandoned as unnecessary, and that broader scope was being adopted of focusing on business enterprises and business activities. Obviously, with respect to activities of a transnational character, which I think Kinder was still wedded to, there are obviously difficulties there in defining what that would be by reference to particular business enterprises. So I do think it brings in that area of complexity, and obviously the interrelationship then between the definitions of business activity and business relationships, which are going to be very key when you then get onto the other concepts, articles in the treaty, which will deal with what activity is going to be regulated, and in particular where liabilities might attach. And I think on that, if all business enterprises are in scope, I think it'll be much easier then to define what those other relevant provisions that are regulated within the scope of the treaty. There doesn't seem to be any logical basis to exclude any business enterprises because, as was noted at the outset, there are many domestically operating entities that can cause severe or be involved in severe human rights impacts. So in principle, that should be the starting point in my view. It would cut out some of this detail that is bogging things down and allow progress to be made. I think it's really important to go back to the guiding principles and the effort there to address governance gaps, and those governance gaps obviously still remain. What is the smart way to go about that in terms of regulation, given that we're still on the international plane have the same considerations around corporate law largely being a domestic issue, the limits of sovereignty and jurisdiction. So for states to come together and think about what it is they're trying to tackle and then articulate that more clearly within the scope of a legally binding instrument. Thanks.
Thanks, Ray, and very much appreciate that practitioner perspective as well, which is really valuable to this discussion. I'll turn finally to Carlos for a few reflections. Again, just to remind everyone of the question, the sort of definition proper of TNCs and business activities of a transnational character, and then we'll delve a little bit more into the question of what's included in the scope and what's not. Carlos, over to you.
Yeah, thank you. Well, I think all of us were going in the same direction in this panel. And I think fundamentally we don't question the way the issue of definition on this part is being addressed. I think I hear Ray not so keen about the second part about the business activities of transnational character, but I think in general, I think we seem to be going in this direction. On my side, I think there are two elements of why we need to keep the two elements in the definition: the business activities on one side and the transnational business activity on the other side. And then one is because there is well, there is an element, some language in the resolution creating the process that puts a special emphasis on the question of transnational corporations. I will be too far in ignoring that and that mandate by just focusing on business activities. I think in general, we have to give some special room, some specific mentioning, reference and treatment to the question of transnational activities. And in going in that direction, I think one element we need to bear in mind also is that this definition is targeting the activities of the actor, not the subject as such. So the subject as a transnational corporation or business enterprise is not addressed, it's the activities. No, and I think this marks a very important difference from the guiding principles or the ILO Declaration of Multinational Enterprises, etc., that provide direct guidance to business enterprises. Now, this instrument is addressing states and creating obligations for states to implement. And the states will have to address specific activities conducted by business enterprises, whether they are of national or transnational character. So I think there's two elements that to be kept. I think in general, the definitions are very close to be agreeable in my view, except for this, of course, the fundamental questions of whether we focus on one or the other, or we even address the question of direct obligations. No, some people are proposing a treaty with direct obligations under international law for business enterprises. I think those things are left aside for the time being. So in the scope where we are, or in the framework where we are, I think these definitions are clear. I would encourage on my side also to be more precise about the kind of economic activity that's being addressed. It's not any other kind of activity, as Kinda has already underlined. This is extremely broad, and there's some repetition or redundancies in the definition of business activities, like talking about transnational activities and business enterprises again, or natural legal persons again, etc. So in relation to a business of transnational character, I think that's a definition that needs substantive working. I think as such resembles very much what is already used in other international conventions addressing different kind of phenomena, international economic crime, such as organized crime and financial issues, financing of terrorism, etc. I think we are not talking about the same issue here. I think we have to adopt something a bit substantially different and make an emphasis, of course, on the transnational, multinational, plurinational character of the activity, but also stating more clearly that this activity involves the control or contribution by one actor over the other. No, because that's what means is basically the issue. What basically means the question or the problem of the transnational activity is when one activity in one country, one particular actor has the means to control through ownership or other ways the way the conduct of the activity in other countries is occurring, the activities by other small business enterprises. I think that's what defines the transnational phenomenon here, and it is very clearly stated in the definition and so-called definition of the ILO Declaration on M&Es. Talks about ownership and control. I think we need to rescue that element also. This has to be, I think my time is up, but I think just to call the attention that this definition cannot be understood fully if separated completely from Article 3 on scope. And there, I think is where everything we are discussing comes down to. I think there might be other webinar for this, but I think we have to understand the two together. Thanks.
Thanks, Carlos, and that's a great conclusion to that first question. I'm gonna skip us ahead because we've started to wade into the sort of differences between the two key options on the scope. So TNCs and other business enterprises of transnational character, or all business enterprises, irrespective of their transnational character. But I think, and as you all, I'll come to you in light of those different options as a kind of community legal practitioner working with communities and rights holders at the front line, often of corporate abuse. Would you reflect for a moment on the benefits and limitations of either of the options that we've started to discuss already, preferably through examples that highlight the legal implications of those options in your experience?
Thank you, Michael. This is for me, right?
Yes, please come in. We'd love to hear your thoughts.
All right. Yeah, yes. So thank you so much. Yeah, so really, in practice, I can give you an example of, perhaps the Kabwe, right, case, I think, which maybe a lot of people might be aware of, right? Really, this involved Anglo's operations in Zambia, but then Anglo ended the operations in Zambia. Then, so Anglo was mining lead in Zambia. So now what then happened was that, years later or currently, right, the effects of lead poison, right, in the atmosphere, are still affecting the communities and people of Kabwe, right? Now, the problem then becomes, in the sense that in the laws around, class actions in Zambia, there isn't specific provisions, right, for laws allowing to bring class actions in Zambia. So now the victims there of, human rights are left now with no option, right, to bring litigation against this TNC in the country where the violation has taken place. So now they had to seek for a remedy in South Africa where the laws, allows for that. But on the other hand, in South Africa, the cause of action, hasn't taken place. So the cause in South Africa, for example, the High Court, where the certification application was heard, was a bit hesitant in allowing for the class action or for to be heard, in South Africa on the basis that, the cause of action didn't take place in South Africa, and also, what will need to be proved, the evidential, information that has to be brought forward, it will be complicated because of that, differences, right, in jurisdiction. So now, having this kind of maybe a legal instrument which put like a universal code or, whereby remedies or victims of human rights are able to bring, right, a dispute, or claim for their rights in a jurisdiction that is most suitable for them, would have made things or life easier, right, for victims of rights, in Zambia. So this is just one of the examples that shows, the complications that are faced by the victims of, human rights violations by TNCs in the jurisdictions, or in the communities that we operate in. Thank you.
Thanks, Nesu. That's a powerful example, I think. Kinda, I'll turn back to you, and please feel free to reflect also a bit on the benefits and limitations of the two scope options. But also, if I could ask you, in practice, what is it going to take, do you think, for the different stakeholders to, on either side of this issue, to be able to align or at least reach some compromise on the issue of scope?
Yes, thank you again. Maybe I want to go back to this idea of starting to focus on discussing scope and definitions in the context of the different operational sections, just to demonstrate how that might help in the discussion. Because, for example, there are sections of the LBI, like Articles 4, 5, and 7, that focus on victims of human rights harm emerging in the context of business activities. So here the issue of all business entities or TNCs does not really arise. And really, if you follow the negotiations and the discussions in the room, it hasn't arisen in that way, because clearly you cannot differentiate between victims in terms of the source of their harm and their rights based on the source of their harm. But also more operationally, the state cannot design its laws in regards to, for example, rights of victims, such as expedited access to information or certain protections or procedural consideration based on, you know, who harmed them. Or so basically in these articles, this discussion of all business or TNCs really doesn't have a place. Then if we come to the prevention and the due diligence, we can see that generally, if we look at the discussion more broadly, there is convergence that all entities could have impact on human rights, which is reflected in the preamble, which is derived from the guiding principles as well and the existing, you know, human rights law, and that setting mandatory human rights due diligence should not create disproportionate burdens on small and medium enterprises. So this is the general dynamic of the discussions. Now, how it is reflected in the language is another thing. But if we look at the language thus far here, the LBI in its current text talks about regulating all business enterprises within the territory, jurisdiction, or otherwise under the control of the concerned state, including those with transnational activities. So basically, in another way, if we don't want to use the notion of business enterprise and all of that, it's basically saying that state parties should regulate the legal persons undertaking business activities within their territory, jurisdictions, or otherwise under control, which is exactly what the guiding principles or also the approach of the which also extends beyond the approach of the European directive, meaning broader. So, and the concern that we have heard from a lot of the developing country delegations about the burdensomeness on SMEs, I think is addressed under this Article 3.2, which allows a margin of discretion for the state in implementing the obligation through national laws to elevate the burden from SMEs based on the size, sector, operational context, etc. And it is very important here to note that this Article 3.2 would not allow a state, for example, to differentiate in the obligation pertaining to due diligence based on whether the business is domestic or foreign. So for example, if there's a foreign investor in that jurisdiction, the state cannot tell them you need to do more just because you are foreign, but it can tell them they need to do more because all the businesses that are of a certain size are doing more in regards to due diligence. So also in the context of the due diligence section, that tension does not really arise as much as we see it when we discuss Article 3 on scope per se as a standing article on its own, you know? And if we look at the other articles on legal liability, really, you know, here we're talking about the liability of legal and natural persons operating in that jurisdiction. Or here, really, if we want to address the transnational aspect, we need to get right the issue of the standard that will be applied in cases that involve more than one entity that operate in more than one jurisdiction and that have a certain influence on each other. This is the key to getting the transnational aspect right under this section on liability. So this is just to give you an example. If we move the discussion on definitions and scope to the context of each of the operational sections or the categories of the operational sections as they work together, then it might become a much easier discussion. Now, I have a lot of comments on the language of the resolution, but maybe I'll come to them later, so I don't take time.
Thanks, Kinda. I think we're all quite interested on your thoughts on that. So we'll try and save some time at the end. I am mindful that time is ticking. So Ray, I'll maybe turn to you just for a final word on either to respond to Kinda's reflections or from your perspective a sort of compromise solution or a way forward or key issues that need to be grappled with. And I think you've reflected on some of them already in in the scope discussion in the coming negotiations. Before I hand over to you, just to remind everyone to please make use of the Q&A box. I do see some questions coming through there, and we'll try to save 7 or so minutes at the end. Ray, over to you. Oh, and just unmute.
Yeah, and there was a lot great comments. Agreed with a lot of what was said by Carlos and Kinder. Going back, and Carlos obviously has the concern about the scope of the mandate, which is obviously a very important consideration. But at this point, excuse me, if that can't be resolved, I may be naive here, but is there not some international consent? If there can be an international consensus, does it not make sense to reconsider or ask the Human Rights Council to reconsider what at this stage is the appropriate scope of the mandate to take the treaty forward? Because if we think about some of the things we've been thinking about, there are some real difficulties that arise from trying to differentiate between the treatment of transnational corporations per se, and it's very difficult to define and then regulate activities of a transnational character. And if we strip those out, it becomes much easier, as I said earlier, to focus on actually what are we trying to achieve here. And in particular, if you think about the situation, for example, in a country, if you have a wealthy individual who owns 2 businesses, for example, one does transnational business, it exports all the goods it manufactures, the other manufactures goods and just distributes them in the domestic market. It could be subject to the due diligence requirements, subject to state action that's been taken to prevent in relation to transnational activities of a transnational character in one factory and completely not having to do anything in the other factory. Yet the workers in those factories are living in the same community, but may be subject to different standards as a result. So that's the real anomaly. I think, as Kinder also recognized, there is an element in Article 3.2. I mean, you could discuss a lot about the details of that and whether it's worded in the right way or what it would consist of. But obviously, to take account of the situation of some businesses that just don't have the capacity or can't be expected to go about these the duties to the same extent as multinational corporations. But again, these risk-based approaches and taking account of the individual circumstances of particular businesses in their context is implicit in the guiding principles. So going back to Fernanda's opening point, which is, smart mix of measures, as with any kind of lawmaking, it's really how do you make it smart? What are we trying to achieve? And then how do you craft it? And so, to get maybe, stripping away from definitions, actually thinking about scope and then building up the latter operative provisions, as Kinder says, is really key. You've got to have some agreement on those fundamental starting points, though. Where there's a compromise, I have no idea, I'm afraid. But to me, some of those fundamental points would make it much easier in practice to get consensus and move forward.
Right, that's excellent. Thank you. And that sounds like the start of a compromise to me anyway. So thanks very much for that. I'm going to open up the floor to questions. I know we have a number coming through in the chat and some that have been sent ahead of time. So Carlos, maybe I'll package a few for you on the issue of remedy, and then Kinder maybe ask you to come in as well. One of the ones that's come through in the chat is does the draft treaty provide provision for claiming remedy by the victims of the Global South from TNCs in the judicial mechanisms of the home state? And I think more generally, we've had a number of queries around how the choice of scope impacts access to remedy for victims of human rights abuses in general. And I think both of those have been slightly touched on before. But Carlos, any reflections on that issue of remedy and its connection to scope or otherwise?
Yeah, thank you. I think the provisions on remedy and legal liability are very clear, or not so clear now in the latest draft that we are discussing. Might be the subject for another webinar, but definitely I think there is a place for just the concern to provide very clearly definitions or standards on legal liability in the context of transnational activity. That's what the question is referring to. Now, if Also, there's an article that addresses the question of jurisdiction, which is, I think, one of the most elaborated in the draft, and has been kept already in the last two drafts, and I think it's a very positive provision. That jurisdiction requires states, actually what that article requires states to provide a very broad jurisdiction of the courts, not to deal also with complaints arising in the context of transnational activities. So yeah, the victims of the Global South, as you say, will have at least a better chance, I think, if states take action in compliance with this kind of treaty, if this kind of article goes through. That's my short and quick question to that. Answer to that question.
Thanks so much, Carlos. And Kinda, maybe I could open the same to you, but add a little addition. We have a question from the chat which says how would an LBI impact the duty of care owed by transnational corporations or others to victims of their extraterritorial activities? So perhaps you could touch on that as well as remedy.
Yeah. So basically, the LBI is trying to, when it comes to legal liability, is trying to, and remedy, it's trying to set a standard that extends beyond, liability pertaining to non-fulfillment of the due diligence obligation to something that is broader and covers liability in regards to the harm, human rights related harm more broadly. And in that sense, the LBI adds a lot of value in comparison to the kind of what we have under the guiding principles, but also what we have under recent practices like the European Directive, which is solely addressing liability in relation to non-fulfillment of the human rights due diligence mandatory obligation. So this is one. The second thing, as Carlos was explaining, is the attempt to clarify the standard of liability that would apply when we have, for example, the parent company in one jurisdiction and the harm arising in another jurisdiction as a result of a subsidiary activities, etc. So the latest text of the LBI does not really address this directly, but previously we have had a lot of lengthy debates, and we had a text that is more or less a good basis to build on, Article 8.6 of the earlier text, that would help us capture that notion of the duty of care arising from the influence of one entity on another entity and the liability that might emerge as a result of this influence, even if it is not full control by one entity over the other. This aspect we were considering to be one of the key added values of the section on legal liability. The last text moved a little bit away from getting this right, but I hear a lot of civil society groups also calling for retrieval of that language and working on it from the previous text. So this is, I think, what Carlos as well was mentioning. So probably, hopefully, this will be done as well. Thank you.
Thanks, Kinda. I'm looking at time, and we have so little left, and there's so many excellent questions that are still in the chat. So what we'll potentially do is try and package them and then send out some answers for from the panelists for those who have attended today. I think that I'm seeing one that's reflecting on how the experiences of victims of corporate human rights abuse are actually being factored into the discussions of scope. And I think Ines, you provided a little bit of reflection on that today, but certainly that's a core priority and something that needs to be kept in mind. I will now hand over to Tato Rafani from Lawyers for Human Rights based in South Africa. They're a partner in today's event, and he'll offer some very brief closing remarks and just to say a big thank you to all of our panelists who I think provided us with a really rich discussion on this critical issue. Tato, over to you.
Thank you so much, Michael. As we draw towards the end of this insightful session, we've heard about the need to clarify the definitions of business activities as well as the transnational nature of companies, which is vital for holding companies accountable across borders, and that the standard is critical to ensuring consistency in corporate responsibility. Interestingly, we also heard that the Cabo case against Anglo-American South Africa reminded us of an urgent need of a legally binding instrument to help communities access remedies when human rights violations occur. And this case shows the gaps that currently exist in the system. Kinder also emphasized on the key to bridge the divide between the treaty proponents and supporters is getting the standard right. And to wrap up, thank you to all our speakers and to all our participants for attending this webinar and others in the series. We hope that this has given you more insight into the key issues to follow during the negotiations in Geneva in December. A recording of all these webinars in the series will be made available on the Business and Human Rights Resource Center's website, as well as the blog series delving deeper into these and other issues in the beginning of November. We'll also be able to provide daily updates on key takeaways during the negotiations themselves, which would also be available on the Resource Center's webpage and social media. Thank you.